And at this point in time, I'm going to close the public hearing. Public hearing is now closed. Okay, council. First I'll begin, I will ask the town solicitor, Mr. Tights, if you will give us a quick overview of this evening and some of the suggestions that we received.
Thank you, Mr. President. I don't have too much to add here. I think we are hearing the same things over and over. I will just say that notwithstanding sentiments that I'm out to get anybody, my first memo on the council's authority to license shooting ranges was back on February 20th, 2014. Before there was any approach for any shooting gallery license or anything. I gave you a memo then, it was public. The zoning and building official came to a different conclusion, and that relates to the zoning. I provided you a supplemental memo on May 8th. I've heard a lot of stuff since then, but I still think that the law is in Rhode Island that this type of operation should be licensed. And based on what we have here in the town of Tiverton with our charter, and we don't have a board of police commissioners, I believe that the town council is the proper licensing authority for it. I do believe that with licensing, this is separate from zoning. The fact that the Tiverton Rod and Gun Club is a pre-existing legal non-conforming use for zoning doesn't change a licensing regulatory ordinance, so I think they would be subject to it, and I think it would be proper for them to be subject to it. In fact, I think it would be unfair to have just one shooting range in the town licensed and not the other. I think they should both be subject to it. Based on my conversations with the attorney and members of the Tiverton Rod and Gun Club, it's my belief that they are capable of complying with the ordinance, with one exception, and I'll get to that in a moment, the insurance. They're capable of complying with the ordinance as is, other than the $200 application fee specified by state law. There's really nothing there. Mr. Regan showed you a large stack of material. They already have a lead management plan. They already have the requirements in place, so I don't think it would be burdensome. The only indication they said would be burdensome would be the insurance. They have $1 million going to $2 million. I don't believe it would be unduly burdensome, although it might double their premium compared to all their expenses. It doesn't seem to be a significant item. And in this day and age, $2 million is not a lot of liability insurance. But I don't feel strongly about that. That's a policy decision. If the town council wanted to amend that, put the insurance back to $1 million. And as I indicated, I would support changing the two definitional sections for now to put the word indoor in, so there's no question that it only applies to indoor at this time. So in sum, that would be my recommendation. The draft D5 as amended with the further amendments of adding indoor before the definitions of shooting gallery and shooting range facility, and whatever your pleasure is on the insurance.
I'll just speak regarding the liability insurance. I think that it should be at $1 million and $2 million aggregate. That seems reasonable.
Mr. President, I just have a couple of quick items I'd like to review. Okay. Starting Division 2 requirements for indoor shooting ranges on page 4.
I'm sorry. Can you just speak up just a little bit?
Yes. Under hours of operation, it's section 821 on page 4. There are two sections, one for pre-existing indoor and one for new applications. And I thought, generally speaking, when we discuss licensing a facility or a use or whatever the liquor license or whatever it is, the hours of operation are set by the license. It's, we say you can operate within, if it's a restaurant, you can operate until midnight, but you can't operate past midnight, or you can't serve liquor. And I think that that would be an appropriate methodology in this instance as well, to maintain the institution of hours of operation to go along with the license, rather than codifying it in an ordinance that's sort of hard and fast. So that would be my recommendation on the hours of operation section. Yeah, we can think about language, and I can make a motion if that's the pleasure.
Yeah,
Okay.
and I think going along with that, I mean, again, any shooter, if they want to shoot on their way to work, obviously, most people start, work before 9 a.m., so that they'd want to get in at 6 or 7, so I think to codify in an ordinance a set
Yeah,
time,
and
it
I
just
think-
kind of restricts, those who are trying to do it either before or after work, or,
And I think it may vary from applicant to applicant, potentially. If we had another situation in future where this didn't quite fit, or if this doesn't fit a current proposed use. So I would suggest let me see. I would suggest eliminating the operate between 9 a.m. and 9 p.m. and include the town council shall consider. Andy, can you help me a little bit? Should the town council, should that be our language, or should we just say it should be set by the licensing?
I think I would, from what I'm hearing you say, I would say just delete B and leave A but without the title,
Okay.
so it apply to both. And delete the lawful pre-existing, so it would
I
just
think
say,
that's fine.
indoor shooting range facilities shall be permitted to operate as licensed by the town council. In setting hours of operation, the town council shall consider the character of the area and the historical use of the shooting range facility, if any. The historical use, if any.
Yeah. So adding if any to section 821A.
and deleting section 821B.
Correct.
Right, and deleting the title of, deleting
Right,
A
A and
and
the
lawful
title.
pre-existing indoor shooting range facilities, lawful pre-existing. It would just start with indoor shooting.
Yep. Everybody got that? Let me see. Next, I've only got a couple. The other is on page 6, 3/4 of the way to the bottom, section 864, the title of which is just required information. And it says the applicant shall provide sufficient information to demonstrate compliance with all the provisions of this ordinance. And I was wondering, Andy, if that is sort of a catch-all that is necessary, because it seems pretty vague.
Yes, it is, it's catch-all.
Okay.
As an applicant, they're required to prove to you that they meet the requirements.
Okay. And so that's just stating that we're going to require the following things, site
That's right.
site plan. Okay, that's fine then. The next page, page 7, under background check, the new language that's purple underlined at the end of the paragraph. Actually, first of all, I want to understand a little bit better and make a recommendation that there's conduct a criminal records check on the owner and lessee, if any, of the property. And I'm wondering if we want to separate the ownership and the use of the property, or rather the ownership of the land and the ownership of the facility. I'm happy to be told why you would rather have, or you would, in addition to having the owner of the facility, want the owner of the land. But it would seem to me that if there was a ground lease scenario, or it was owned by a more complex entity than owned the shooting range, that may get a little bit confusing and complicated, but to no benefit of the town.
Well, I'm kind of modeling it to some degree on liquor licenses, similar public safety concerns. I don't think, it doesn't necessarily have to, it's really more the owner and operator of the, or lessee
Yeah.
of the operation rather than the property. So I guess you could say that instead of
Yeah.
of the property on which the shooting range is to be located, just say,
Of the shooting range facility.
yeah, on the owner and lessee of the shooting range facility.
Yeah.
Owner and lessee, if any, of the
Of the shooting range facility.
of the shooting range facility, and take out is to be located, and then leave the rest, and on the individual designated by the owner to operate it, if different. I guess,
Okay, that's what I would
actually,
suggest.
take out owner there, the individual designated to operate the shooting range facility, if different from the owner or lessee.
Yeah.
I'm not trying to have,
Right.
check everyone there, I just, the people who are running the place
That's what we
should be
want,
checked.
right. That's, and we don't need anybody else. So in the case of a shooting range facility owned or managed by a nonprofit organization or association, the town's police department shall conduct a criminal records check on. So here is where I think it may be a little bit broad, on the officers of that organization or association. And if there are many officers, or do we have one person who is the designated?
I asked that question. I
Okay.
said, is there like a range safety officer or somebody like that? Is there one person in charge? And my understanding, the answer from the Tiverton Rod and Gun Club was there wasn't really, there's a committee and there's a chairman of the committee, but it didn't seem like he should be burdened with that. I think there was a total of 7 officers, so that seemed like a more reasonable thing. And I'm also, yes, this is the only one, but I'm also looking for the whole thing. It is possible that Mr. LeBeau could try to, set up a nonprofit organization to run the shooting range there.
Okay.
So the officers are the ones legally responsible. You file your Secretary of State
Okay.
statement every year. Seem to be a manageable number.
Okay, so I won't talk too much about that. The next and last suggestion I have is on the very bottom of page 8, under section 8-84, subsection C, where it discusses suspension of license for reasons
Yes.
of public safety. My question is it appropriate to insert the word immediate before public safety in the event, in the first sentence? The chief of police may suspend any license for reasons of immediate public safety. I don't know if that has,
I think it's a bit redundant.
okay.
I think the public safety would make it immediate. But I don't feel strongly about it.
Okay. I read it as public safety, and I don't want that to be interpreted as
Okay.
general kind of
Okay.
all-encompassing public safety.
So we could add immediate
Okay.
before it.
Do we need to qualify what, I think we all, my only concern with words like that is how do we operationally define immediate?
Yeah, and what I would suggest is there's a second clause in there that discusses the timeline in which the town council would act on such a thing, and it is my thinking, at least in a non-legal sense, was the quickest the town council can act is the next regularly scheduled meeting, so I would imagine anything short of that would constitute something more immediate. It's
mean-
not something we could handle.
Right. This is to deal with something, you're not like the Providence Board of Licenses holding a meeting
Right,
on a
right.
Friday night when there was a shooting at a club, to suspend something
Right.
immediately. I suspect, I guess, if you did have a liquor license establishment like that here in Tiverton, we might actually try to have an emergency council meeting. But my thought here was that the police chief would have the authority for the immediate suspension, but it wouldn't, kind of like a temporary restraining order, it couldn't
Yeah.
last long. It could only last until they could have a formal
Right.
hearing before the council.
And that's what my thought was as well.
Yeah.
And-
I think it lays it out that way, so until the next regularly scheduled town council meeting, so that falls within. And again, I think immediate, I don't think we need that. Public safety, I believe that, he's going to realize if it's a public safety issue, it's immediate.
So we would add immediate to both clauses there before the words public safety. The one about the police chief and the one about the council. We would add the word immediate before public safety for reasons of, the same thing with the town council. If the town council were taking action without a show cause hearing, it would also need
Yes,
to be an
I'm sorry,
immediate
yes. Yeah,
public safety
correct.
reason.
And that's all I had, and I'm happy to make motions on all of those individually if that,
Can I just go back and ask, what was the statement in the beginning about the insurance? 1 million per occurrence and 2 million total, was that?
Aggregate, yes.
Aggregate, okay.
and I will move that we edit the, sorry, go ahead.
Anything else, Andy? Okay, because what I want to do is to move this so that we're all in agreement. Let's take this portion now, and if you would make your motions now.
Yeah, so I would move that we change section 8-7 liability insurance to read the first sentence, the licensee shall be required to carry a minimum of $1 million per occurrence. Hang on.
And 2
Let's
million
do it.
aggregate.
Let's do it this way. The licensee shall be required to carry liability insurance with a minimum of $1 million per occurrence and $2 million in the aggregate. Period.
That's your motion?
That is my
We
motion.
have a motion. Do we have a second?
I'll second that.
And we have a second. Any discussion?
I think it goes a little bit too far to say 2 million in the aggregate. I think it's just appropriate, just the 1 million, and that, leave it at that.
I'm in health insurance, I'm not in property and casualty here. So can we just define what the 2 million aggregate is and whether or not from a policy perspective,
If
do
I'm
we
not-
need to specify that?
I think,
not.
if I'm not mistaken, that means that it's up to a maximum of 2 million.
Right. It
It
means if one person is,
One person is $1 million, but if you have 2 people or 100 people.
It's 2
It never
million.
adds up to more than 2 million.
Okay.
That would be the aggregate.
Okay, thank you.
So is that an unwise assumption to make? Maybe we just keep it at a million per occurrence? I mean, it's going to be determined by the policy itself, and if the
No,
policy is 1-2, then it's
Right.
1-2.
I mean, the normal way to specify it would be to have it both. If you have a limit, if you just say 1 million, then that's going to be the aggregate, and they could have a lesser amount per occurrence. So it does make better sense to specify both the individual per claim and per occurrence, per occurrence and in the aggregate.
Okay.
I guess my only question is that a standard policy or is that something that is not typically underwritten for purposes of liability insurance?
Well, Andy can correct me if I'm wrong, but I think most insurance policies, when it comes to liability, have an aggregate.
Yes.
Because the insurance company doesn't want to,
Right.
for example,
Right.
if it's $1
Actually,
million.
all policies,
Yeah.
all policies have an aggregate. Most policies also have individual limits. If they don't specify, then the individual limit is the aggregate. So if you just had 2 million in the aggregate, then if it didn't specify, you could have one person and could collect up to 2 million. But they usually specify both limits. But every policy has an aggregate. Whatever you pay for, that's the maximum you're going to get.
Okay.
I'm not going to get into reinsurance.
Please
but-
don't.
Anything further?
Yes, I have a quick question. I believe the president for Rod Gun Club is still here.
I'm sorry, Jim, could you speak up?
All right. Is the president for the Tiverton Rod Gun Club still present? Mr. Deans. Is there anything that actually requires your range, any regulation now that requires the range to have insurance? Are you regulated to have insurance now?
I'm hesitant to be, but before we get, I'm really hesitant to have this.
Can I get an
we
answer
close
first,
the
please?
public
Can I get an
hearing.
answer first, please?
Jim, if I think I'm interpreting your question right, from a liability standpoint, of course, we're carrying that insurance to protect the
Does anything require you to carry it? Is there a federal regulation?
state law, federal law, not that I'm
No.
aware of.
Okay.
Anyone else from the council? Okay, we have a motion and a second. The motion is the licensee shall be required to carry liability insurance in the minimum of $1 million and $2 million in the aggregate. Am I correct, Mr.?
Yeah, only,
Pelletier.
it's 1 million per occurrence and
Per
2 million in
occurrence.
the aggregate.
So we have a motion and second. All those in favor? Opposed?
Wait a minute,
Okay, we have,
Nancy
We're gonna
can't
hold
see
them up
this.
a little longer.
I'm just going to give it to you. Okay, it is 5-2 with counts, excuse me, 5-3,
4-3.
4-3. I can't see. I believe it was Councilor Shabbat and Councilor.
Want to just do a roll call
Voting
so
no.
Nancy can hear?
Let's do that.
Councilor Ruda, and you want a voice?
Why don't you just do a roll call?
I will do a roll call, starting with Mr.
Gerlach.
Gerlach.
Yes.
Nay.
Nay.
Yes.
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 Did you get it?
So I would move that we
It's 4-3.
amend Section 8-21 hours of operation the following. Removing A, lawful pre-existing indoor shooting range facilities, and the first two words in that sentence, lawful pre-existing. Adding, if any, at the end of the paragraph, with a comma or semicolon. And then totally eliminating Section B, new indoor shooting range facilities.
Okay, we have a motion.
I'll second.
Second discussion. Anything from the council?
So just so everyone's just so everyone's clear, this makes hours of operation a portion of the discussion during the actual licensing of the individual
Correct.
facility or entity and not codified in the ordinance, correct?
Correct.
So it leaves it loosey-goosey and not specific, so why have it?
How do we, so just a point of clarification, how do we, the precedent with other licensing activities, and I'm trying to remember past licensing discussions, are hours of operation, we talk as part of the licensing
Yeah, usually
discussion,
the
right?
business comes forward and say, these are the hours we would like to operate. And then, your discussion
Yeah.
ensues, does it make sense to the type of business?
My concern is just making sure things are standard across all of our discussions for whatever sort of license we're talking about.
Anything else from the council? Okay, we have a motion and second. All those in favor by voice, starting with Mr. Gerlach?
Aye.
Nay.
Nay.
Aye.
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 Okay. Next, Mr. Pelletier?
Sorry. Let's see. Okay, Section 8-66 background check. I move that we, all right, here, I'm going to read, Nancy, I'm going to read what I want this to look like instead of saying we're going to cut out and put in and whatnot. Upon receipt of an application by an unlicensed shooting range facility, the town's police department shall conduct a criminal records check on the owner and lessee, if any, of the shooting range facility and on the, right? Okay, no, sorry, and on the individual designated to operate the shooting facility, comma, if different from the owner.
Or lessee. Or lessee.
or lessee. And that's it.
Okay, we have a motion.
I'll second it to get to discussion.
Discussion.
This is effectively eliminating the requirement to have background checks on a property owner or, well, a property owner in the event that they are not also the operator of the facility.
Right.
So if you owned the property and you leased it to someone who operated a shooting range, you would not be required to have a background check just by happening to own the property if you have no operational duties whatsoever in the property. Does that make sense?
Yep.
Okay. So what this initially said was the person who owns the land, the person that owns the building, the person who leases the building, the person who everybody, the tenant, the landowner, everyone, and the people who actually operate the facility would be subject to a background check. What I'm suggesting is the only people we need to subject to a background check are the people who are actually running the facility to be licensed, not the landlord, not the little old lady that lives in New Hampshire that owns the piece of land, none of that. Just the person who is actively involved.
Brett, if you wanted to set this thing up, an owner could always have control. When all is said and done, money means control. So if you own the property, you own the facility, you can put up as many obstacles as possible. You can put any number of frontmen in front of you to hide the true operation. But when it's all said and done, trace the money. It goes back to the owner. I would suggest that we leave the language just as it is. I think you're giving people an out. If you owned a piece of property and you wanted to build one of these shooting gallery facilities, get your put it in your brother-in-law's name and say he's leasing it, and now you've avoided any background check. You follow? I mean, it's just
I do.
It seems to be an avoidance issue.
I think alternatively, in the event that someone who has absolutely no involvement in operating a facility like this would be subject to a background check, even if they had they had a master ground lease arrangement, that they would still be subject to a background check. And I don't know how, I can't imagine how that is fruitful for the town of Tiverton, or the property owner, or the tenant, or anyone. If that property owner who has no relationship aside from leasing a piece of property to someone fails a background check, are we going to deny the license on those grounds? I should hope not.
Yeah, and I understand you're saying, somebody could do a shell game or so, on us. But I think anyone who is going to be leasing that type of property in the future, obviously will know what kind of business it's going to be, that it would be under scrutiny, so that, and unfortunately, I think that usually if someone is tainted, usually the people they associate with are usually tainted also. So I think that forcing a property owner, if they have nothing to do with the actual business, to go underground under a background check is really to no benefit or avail to the town.
And sort of tapping into the conniving aspect of my brain just then, if you wanted to circumvent even how it's written now, you would just set up a trust or something and name your brother-in-law as the trustee, and then you're out of the game altogether. So, I mean, I certainly think that there are people who potentially down the road would try to circumvent that if the worst case scenario, but I just don't see that as a reasonable.
forgive my ignorance here, but can someone help me understand the actual process of a background check and to what extent the individual for whom the check is being executed on is involved? Is it onerous? Is it, I just don't know what that process is.
Mr. Gerlach, are you asking what the process is on the background check itself?
Yes, please.
I don't know all the particulars, but it's to see if they have a criminal record.
No, I understand that, but as the individual, let's say you were doing a background check with me, am I an active or passive participant in that background check? Meaning, do I have to take time out of work to go to the police station and answer a questionnaire or whatever that is, or am I simply giving my name and a social security number and all that magic happens in the background?
I don't think
Can I
you have
answer
to
that?
take time.
It is, I think the
Right.
police chief is here, and he could answer that question.
I'm just trying to gauge how onerous
Yeah, Chief
the
Blakey.
background check is physically on the individual.
I mean, I had when I went to the
Because if it's not all that, if it's not all that onerous, then
social security number
Good evening, Mr. Gerlach. No, you would not have to
Sorry.
appear. You'd have,
Can't hear
your
you.
application,
Sorry.
your application would have the information necessary to be a background check, a criminal check, a BCI check. That would be done on the individual applying for the license.
So I'm just filling
You
out.
would not have to appear.
Okay, thanks.
Chief, while you're still there, to the best of your knowledge, do we do this sort of second layer of background check for property owners in other situations where we have licenses, like liquor
Currently,
licenses?
Currently, we do not.
No, okay. So, thank you.
Welcome.
Thank you, Chief.
One,
Oh, do you have another question for the chief? Chief, don't go.
Don't go away.
Yes, sir.
just a couple of questions. When you gave the retail license to sell firearms to Mr. LeBeau's gun shop, did you have to do a background check?
Yes.
When you do a concealed carry permit, do you have to do a background check?
Extensive.
When a person buys a gun, is there a background check done, a BCI
Yes.
check done?
Yes, there is.
So the nature of this type of business, being a gun, firearm business, would require background checks anyway for people to run the shop.
Currently, we don't have a license for the shop, so there
But
wouldn't be.
they would already have gone through a background check to have the retail license, correct?
But if
Not,
we have,
not at this time. For a retail, for the firearms permits would have to purchase a firearm, to sell a firearm, all that would be applicable. But this is, you're asking me if they would do a background check for a current license? There is no license to check on right now.
For the retail sale of firearms.
Yes, we do.
So
the-
there is a license that's required for a gun shop, and there is already a background check that is performed.
Correct.
So this is basically redundant in that the firearm industry is already regulated at the federal, state level for background checks. People who own guns know this because they have to go through background checks every time they buy or transfer a gun.
Correct.
So this is redundant. These people already have background checks. And it's not just the owners, it's not just the operator, it's the people who will actually go to the gun range. They've bought or transferred a gun, have received their concealed carry permit, they have already had background checks completed and have passed, because otherwise they would not be able to transfer or buy a gun, or they would not be able to have a concealed carry permit. Thank you, Chief.
Thank you.
I will concede
Okay,
all of those points. I just want to make one. We have to, if nothing else, acknowledge that there are two separate and very specific businesses in this scenario we're talking about. There is a retail store, which we are not talking about tonight, because that is regulated in a whole nother arena. We're only talking about the indoor shooting range. We could have next week someone come to us and say, I just want an indoor shooting range, in a zone that is legal And those regulations go away because there's no retail component to it. And so that's what I'm trying to, while I agree, you want to buy a gun, you want to sell a gun, you want to be in retail sales, you need to have those, but those don't necessarily transfer in every situation. We could have a separate individual company organization that wants to open an indoor shooting range that has no retail sales component, and we're talking about a totally different organization. That's why I'm sensitive to that.
Again, being a gun owner, and I have had to have several background checks done every single time, and the people who are using these facilities most likely have had background checks done.
We're only asking for background checks on the people who own the facility, not the users, not the guy that walks in the door, not the trainee, not the trainer. We're only asking for the person who is held responsible for the operation of the facility. And if it's a nonprofit or an organization, then it's the executive board. And if it's a corporation or an LLC or an LLP or whatever it is, then it's the person who is the owner of the facility and the operator of the facility. And I'm trying to reduce the amount of background checks we're requiring.
And I believe the chief said that owners of particular properties are not, the background check is not run on the owners, it's run on the operators of a business.
Jones, but we are proposing in this ordinance to do just the opposite of what you've just said. That's what that's what I'm trying to take out. We're trying to take out the property owners and the leaseholders and the people who are just tangentially related by a real estate deal, and just focus on background checks for the people who actually operate and will hold the license, and no one else, because it's not relevant to the exercise.
I mean, they could be one and the same.
Correct. If you owned the land, you owned the building, and you owned the facility, easy peasy. One background check.
What?
Sorry if you could.
I could be mistaken, but I believe that state law probably requires background checks to be held on operators of a gun range. And I would imagine you can't operate a gun range without proper background checks
Well, there's nothing
already.
in the law that says that, though.
Well, I don't know, I'll ask the chief and then I'll ask.
I'm not aware, not to my
No,
knowledge.
you're not aware of.
If you were a manager of a facility, you could stay behind the scenes and run the whole show with never going on the actual range and still be in charge of it.
Right, but if that manager owned a gun, there's already been a background check on that manager who may be shooting at the range.
If he's a gun owner, there's been a background check, yes.
Right. So just the manager alone, who let's suppose isn't going to shoot, then he wouldn't have.
Well, what's at issue, if you are running a business,
You're responsible.
you are responsible. If I'm a brain surgeon and I let my secretary do the surgery, no, I mean, basically, if I let my secretary do the surgery because she works for me, no one's going to check whether or not her license is there, she accredited or whatnot, and this is the same thing. The owner or operator is the one that the background check has to be on.
You require background checks for private investigators' licenses. What else? You don't have to carry a gun if you're a private investigator.
Yes, we do background checks on private detectives, yes.
And what
And they don't
what
have to
else?
carry a
Anything else?
Beg your pardon?
Any other licenses do we do background checks? Alcohol,
Some liquor establishments.
tobacco.
Liquor establishments, tobacco.
I'm sorry, say it again?
Liquor
Oh.
establishments.
So anybody that wants a liquor license, whether it's a bar or a restaurant or a liquor store, someone who's selling tobacco, someone who's wants to be a private detective, all of those things require background checks on only the person that is doing the actual investigating, holding of the license. Whoever holds the license is who we want to to focus the background check on, not everybody else.
But the owner of the business does.
I think in many instances, and you don't want to necessarily project into the future in hypotheticals, but I think in many instances, for this particular usage, is probably someone who's gone through a background check. But I think by having this in here, it's a proper safety net for those instances where it might not be that case, where it might be an individual who just wants to set up a shooting gallery, or frankly, it might be an individual who just, wants to own and operate, but I don't know, maybe they don't even fire a gun. Like, I don't know. But for me, this is an appropriate kind of, again, safety net that allows us just to make sure that we have done the proper level of background checks required to ensure that the folks who are running the day-to-day operations in this sort of establishment have passed muster.
Okay. Anything else from the council? Okay, we have a motion and a second. We will have a roll call vote, starting with Mr. Gerlach.
Can you reread the change to the section?
Nancy, do you want to do that, or should I? Where is Nancy? Oh, jeez. Oh, okay, I can read it again. Go ahead, Andy.
Sure.
I have a lot of scribbles.
Upon receipt of an application by an unlicensed shooting range facility, the town's police department shall conduct a criminal records check on the owner and lessee, if any, of the shooting range facility, and on the individual designated to operate the shooting range facility, if different from the owner or lessee.
And then the rest is...
So the rest stays the same.
So Brett, I'm confused because I thought you wanted to eliminate the background check on the owner.
Of the
I
property
want
is
to
what we took
eliminate
out.
the background check requirement that this section originally had on the owner of the property or the lessee of the property if they were not the same person as the operator of the business.
So it should be specific, the owner of the business.
It is. We just said that. We said,
That's why
if
we-
any of
that's-
the shooting range facility and on the individual designated to operate the shooting range facility, if different from the owner or lessee.
You took out property owner, so it leaves it open. It's not specific. It says owner.
It says owner.
Of the shooting range facility.
It says owner of the shooting range facility. It's the only thing we're discussing. It's the license we are discussing. It doesn't reference the property or the ground or the building or anything. It's the background check on the person who owns or leases the shooting range facility.
Facility.
And, I'm sorry, go ahead. What'd you say?
Go ahead.
I thought you started to say something and I...
Facility to me means a building.
No, it's
But I think we have to-
defined in the first paragraph.
You can own a building, but not own the land. And what we're taking out is, if the owner of the land is not the person who owns that building or leases that building.
So, Joan, your point is that facility, in this instance, you are operationally defining as the physical structure where I think where you're going is the business owner.
Correct.
Okay, on page 2, our definitions, new shooting range facility means an indoor shooting range facility that was not lawfully pre-existing as of a date to be inserted.
Okay.
That is the entity, the operation of the facility, not the physical asset of the building or the ground underneath, or the mineral rights or the air rights or any of that real estate stuff. Is there a better way to state that than what we've done?
Well, the definition of shooting range facility does include parking areas, structures. So that means to me that it's a building, and
I'm
it's
so-
associated parking lot and everything else.
What? Where is it?
Definitions, page 2.
I'm sorry?
Definitions, page 2, the definition of shooting range facility.
Okay.
Okay.
So what's
I don't
what's your question
understand.
regarding that definition?
You want the business owner, the owner of the operation.
Right. So here is, I think, how that is resolved in, it's the second part of that sentence, is the owner and lessee of the shooting range facility and, or you could say, or, an individual designated to operate the shooting range facility if it's different from the owner or lessee. So I guess if we want to take it another level, there can be a tertiary level of ownership where you owned the building, but you didn't own the land. You leased the building to someone else, and they operated the facility. That person, the operator of the facility, would then be required to have a background check. The landowner and the building owner would not. Andy, is that correct, or am I?
Yes, that's correct.
I thought it was fine the first time around.
That's because you wrote it.
Can't hear you down here.
I said that's because he wrote it.
No, I'm saying I thought it was fine as you amended it.
Oh, that's what I'm asking.
That's what I meant. I thought it was fine as you amended
That's
it. You
nice
had
of
a,
you to say.
you had a good point. We don't need to burden the landlord if the
Right.
landlord isn't operating things. So I thought your language was fine.
Okay. Thank you. I apologize.
Anything else from the council? Okay, we have a motion and a second. We'll have a roll call vote, starting with Mr. Gerlach.
Aye.
Nay.
Nay.
Aye.
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 Aye. Just the last one is page 8 at the bottom, penalty for shooting range facility violations of this ordinance, section 8-84. I would suggest that we insert under subsection C, the word immediate in front of, between of public safety, between of and public immediate, so the section would read, the chief of police may suspend any license for reasons of immediate public safety. And then also, the second sentence, the town council may, on its own, suspend any license for reasons of immediate public safety. And then that would allow for the next council meeting to have a show cause hearing.
Okay, we have a motion. Do we have a second?
I'll second for discussion.
Okay, discussion?
What was the second change?
The second change is to put immediate on the sentence with, so it reads, the town council may on its own suspend any license for reasons of immediate public safety.
Okay, anything else from the council? Okay, we'll have a roll call vote, beginning with Mr. Gerlach.
Aye.
Nay.
Nay.
Aye.
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 Aye. That's all I've got.
Is that all you have, Mr. Pelletier?
all I've got.
Okay, anyone else from the council with changes?
Yeah. So anywhere that it says outdoor, we need to cross that out because this is an indoor policy. Is that correct?
Yeah, I think it only appears a couple.
It appears where we were just talking about the new shooting range facility.
Yep.
And I'm not quite sure if I see it anywhere else. It's one other place. And we're leaving all the pre-existing exempt,
Yep.
correct? Yes. So this would be for new shooting ranges, new indoor shooting ranges only.
Well, no.
But that's what I'm asking.
No.
So
This whole-
pre-existing would have to go for a license also.
Yes.
Definitions for the facility. This is here. This.
So Denise, I'm sorry, I'm really trying to
I would like
find
to
where
ask
the
Mr. Means
word
something.
outdoor is used.
Sorry, say it again?
I'm trying to figure out where Denise is looking at, where the word outdoor is currently used.
The new shooting range facility means a shooting facility, and it says indoor, either indoor or outdoor. We just want to put indoor there.
I'm sorry, Denise, section, page?
It would be 2. Page 2 of the cleanup version,
Okay.
the definition that we were just talking about, the new shooting range facility.
It should read something like new shooting range facility means an indoor shooting
shooting
range
range.
facility that was not lawfully pre-existing as of date of passage to be inserted, which is when we vote on this.
Now, I have a question if I'm allowed. I'd like Mr. Means to answer this. How would this hurt your facility as written now? Because you did, the two lawyers got together and put this together. Would this hurt, well,
Mr.
with
President,
discussion.
I really, we can't have, without opening up the public hearing, we can't have people from the audience speaking
I've been
on
hearing
this.
from Mr. LeBeau that this is going to hurt his facility. I do believe that the
Denise,
Rod and Gun...
unless you want to hear from Mr. LeBeau and everybody else in the auditorium again, you can't be hearing from these people.
Okay, that's fine, then I cannot vote for this.
Well, I would just state that from my notations throughout the ordinance that we're talking about right now, as amended, would require any applicant, which would include both the Rod and Gun Club and the Secundit Outfitters, only the indoor range facilities, to file an application, pay a $200 application fee, submit a site plan that shows where their property is and its boundaries and where the building that is going to be used for indoor shooting would be. They would submit to a background check for the owner or operator of the facility, and there would be a public hearing where we would sit as the licensing board and set, among other things, we would either grant the license or not grant the license, and if we granted the license, we would set the hours of operation. And then that would be renewable every year, but would only require an application for renewal and no advertising requirement aside from the newspaper advertisement for the public hearing. The general, just every year we get them, it would be an annual license. That's my round numbers. I will, for expedition purposes, I will move that we change the definition of new shooting range facility on page 2 to read, new shooting range facility means an indoor shooting range facility that was not lawfully pre-existing as of, brackets, date of passage to be inserted, and close brackets, period, which will presumably be the date at which this is passed, if it is passed.
Do you want to do the other two definitions below while you're there?
The other two definitions below.
Shooting gallery and shooting range facility would both have indoor.
Yes, okay, and also, let's change shooting gallery, definition 2. Shooting gallery is the term used by the Rhode Island General Assembly, and for the purposes of this ordinance, is the same as an indoor shooting range or indoor shooting range facility. And then we will change the definition of shooting range facility to indoor shooting range facility. Means a public or private facility, including individual shooting ranges, safety fans, or shot fall zones, structures, parking areas, and other associated improvements designed for the purpose of providing a place for the discharge of various types of firearms and the practice of archery. Period.
Want to add one more indoor?
Indoors, yeah, I was
About-
going to,
of
but I didn't want to-
providing an indoor place.
Providing an indoor place for the discharge of various types of firearms and the practice of archery.
That way there can be no misunderstanding.
I think it would be beneficial just to just walk through those just one more time.
I didn't hear any of that, I'm sorry.
He wanted us to walk.
Let's just
through it
walk
one
through
more
those
time.
Edits one more time.
All right, you want me?
Yeah, Andy, why don't you go through
Okay.
the new
All right,
updated
the
definitions?
definition for new shooting range facility would be, new shooting range facility means an indoor shooting range facility that was not lawfully pre-existing as of the date of passage. Then moving down, 3 definitions, shooting gallery would have indoor added twice, so it would read, shooting gallery is the term used by the Rhode Island General Assembly, and for the purposes of this ordinance is the same as indoor shooting range or indoor shooting range facility. And then the next one would have added indoor twice at the very beginning. Indoor shooting range facility means a public or private facility, et cetera, et cetera. And at the end, designed for the purposes of providing an indoor place for the discharge of various types of firearms or the practices of archery.
I believe we need a second.
Yes, it does.
Do we need a second on that
Yes, you
motion?
do.
Yeah, we need a second.
I'll second.
Any discussion?
Is archery performed in an indoor range?
I have shot archery in an indoor range
I
before.
didn't hear.
Just
I didn't
checking.
hear that.
Yep.
I've never seen it done.
I didn't hear that. What was that?
Can archery be performed in an indoor range?
Yeah,
Yes.
I've done it.
Yes.
Absolutely.
Okay, we have a motion, second. Any further discussion? Okay, we will have a roll call vote, beginning with Mr. Gerlach.
Aye.
Nay.
Nay.
Aye.
Aye.
Nay.
Aye.
Motion carries. Okay. Any other counselor with changes? Mr. Lambert?
Nope.
Anybody?
Nope.
Actually, I just have some comments.
No, I'm sorry. Before we go. Thank you, Chief.
No, Chief, I need you, Chief. Chief, come back, come back.
Chief?
Chief, come back.
No, she really wants you back.
Come back. Come back.
Just for the cleanliness, I'm going to move the ordinance as drafted and edited for discussion, and we can have discussion in that period.
Yep.
So it's a little bit more official.
Hi, Chief.
Evening.
Just a quick
Need a
question.
second.
I'd like to
You
know
need a
if there
second.
have been any complaints
Second.
Thank
for
you.
shooting, improper shooting, weapons issues in the town.
Yes. Usually it's hunting related.
It's usually what?
You're hunting related, hunting
Hunt-
season, and there are some complaints about range shooting, yes.
Thank you. I think you can go now.
Thank you.
Thanks, Chief. I didn't want him to get away. He's quick. I do have some just basic questions, and this is for the solicitor. Because based upon the changes required from the feedback from various or actually I should say, one gun club. I don't know if the solicitor understands shooting ranges. I also want to know, were any ordinances reviewed that were specific to Rhode Island?
Mr. Tights?
Yes, no, we did not find any ordinances in Rhode Island. We reviewed other ordinances from other states. And I believe that I have a basic understanding of indoor shooting ranges, as I said earlier. I believe that I do not have a sufficient understanding as to outdoor shooting ranges.
Did you see any licensing in the state of Rhode Island for any type of gun range in your research?
I didn't see any other than the statutory framework. From what I can tell, there are very few new gun ranges, as we heard from the testimony here. There are a lot of sportsmen's clubs which have existed for the better part of a century or more and pre-exist the regulations and so forth. There are new ones that are coming on the scene, but I did not see any current regulation of them.
Did you contact Coventry, since they do have an indoor shooting range that is a commercial use? Specifically mid-state gun?
No, I didn't. To my knowledge, a review of their ordinances did not show a regulation on that.
Did you review the Middletown ordinance that was considered in 2004 that was defeated?
No, because it was defeated. I am aware of the situation. I'm aware of situations in South Kingstown and Middletown where there was issues of people raising that bullets were found far off beyond the distance from the range. And I was personally involved in the one South Kingstown several years ago in connection with a subdivision that was being considered downrange from an outdoor shooting range.
So I understand that the ordinances that were considered in other towns were due to incidences with potential or possible shooting incidences with bullets on private property outside the gun range.
The two that I'm aware of are. That's why we're not dealing with the outdoor ranges at this time. I strictly limited it as amended to the indoor ranges to comply with what I see as the requirement of the state law for there to be licensed.
I think an individual that spoke asked why we were doing this. So I have to ask the council, why do you think we are doing this, putting in this ordinance? There has been no incident of shooting accidents or shooting incidents where bullets were found on other private property. So why are we doing this?
I will only speak for myself. This is a new business in town. We do not have an indoor shooting gallery, and one that is poised on a main street in our town. So I think the better part of being aware and knowing what is going on and ensuring that whatever business that goes in there is regulated and has a license and will be properly operated, and I'm sure Mr. LeBeau will do that. But we have no history and no assurances. So personally, I believe we need to do this. Because if another one opens up and another one opens up and another one opens up, and we do not have some sort of ordinance or licensing policy in place, we could find ourselves with substandard and issues with guns. Maybe they don't build it as well as Mr. LeBeau is saying he's going to build it. What if a bullet goes through a wall? So I think these are the things that we have to take a stand today. I am not a gun owner, but I'm not against guns. But I think we need to know if we're going to have that type of business in our town on a main street, then we have to at least have some sort of regulation on it.
And I do agree with new indoor facilities, definitely, but the pre-existing one that's never had a problem, that is not in the middle of Main Road in Tiverton, that's my only problem with this ordinance. I do think the new people coming into town who are going to put facilities on the main street, then yes. But I'm not quite sure about the pre-existing one. And that's my only hesitation right now.
But again,
So,
if you're
so
going to be fair,
basically, so basically you're targeting a business because it plans are to put it on Main Road. But if it was to be built in the industrial park or on Fish Road,
no,
that
No.
would be a different story.
no.
I'm saying new. I'm sorry, I didn't mean Main Road. New.
I'll throw in my opinion because I was asked for it. I'm not sympathetic to whether or not a facility is new or whether it's on Main Road or whether it's on Highland Road or whether it's on my front lawn. If we have an ordinance, it applies to everyone that it falls under. And we try and work with those parties to make sure that an equitable arrangement can be made both for new folks and pre-existing folks. When we talk about pre-existing uses, we're talking about zoning, nothing to do with the licensing thereof. And I also don't care if none of the other towns or cities in the state of Rhode Island have licensing ordinances or restrictions or covenants or anything like that. I wasn't elected by the people of Coventry. I wasn't elected by the people of Middletown. I was elected by the people of Tiverton, and I'm concerned with what goes on in Tiverton. And as I said earlier in the night, I, as a counselor up here, and I think everybody that holds office in this town, on the first day they get sworn in, they swear to uphold all the laws of the state of Rhode Island, all the laws of the Constitution, all the et cetera, et cetera, et cetera. And I have been told by legal counsel, and I agree with him in my interpretation and my reading of the statute, that licensing of indoor shooting facilities is required under Rhode Island state law. It's one thing to not have known that for 80 years, and although I'm only 30, 81 years can go back to the people who were here in my seat before me. That's one thing, to be ignorant of the fact that the law exists. But to be on notice that the law exists and I am not enforcing it leads me to the conclusion that we have to come up with a reasonable ordinance that provides licensing for these facilities. And I think most of the people that I talk to in the public have said, well, a license doesn't make, it's not crazy talk. If I sell cigarettes or gasoline or antiques or used goods, or you want to list the number of things that Rhode Island state law requires us or enables us to license. If you want to do business on a Sunday or a holiday, you need a special license. To sell alcohol, hotel licenses, and all that. I think it's a very minimal step in assuring people in the town, and also gathering the information that we need as a government to understand where they are, who's in charge of them, and make sure that we've got appropriate measures in place. And I think this does it. There's an application that's probably going to be 1 page or 2 pages with supporting documents, a fee that you have to pay, a licensing fee. You have to provide a site plan of where your facility is going to be located in relationship to the boundaries of the property and the surrounding residences, which if you're building a facility and you don't have some site plan work done, then you've got bigger problems than the license. You're going to have a background check on 1 to probably 8 people, and you're going to have a hearing in front of the town council where we'll grant the license or not grant the license and set parameters or not set parameters on the hours of operation. It's hard to make the argument that someone who wants to open an indoor shooting range, which by design is meant to be very safe and very quiet and respectful and all of these things, because it's bad business to do it otherwise. But it's difficult to sell to someone off the street that doesn't need a license. But if you sell a pack of cigarettes, you need a license. Or if you sell beer, you need a license. Or if you're a private investigator, you need a license. Or if you want to sell snow cones out of a van, you need a license from the town of Tiverton. That's why I think this is appropriate.
Anything else from the council?
I think from a basic premise is that you have state law that regulates shooting galleries that goes back to the 1930s when there weren't shooting ranges. So shooting galleries definitely needed regulation because they were shooting pellet guns. They could have been just a cardboard backdrop. So I can see where shooting galleries in that context would require some licensing. But when you talk about gun ranges, as exists at the Tiverton Run Gun Club and the gun clubs across the state, and even new facilities, gun shooting range facilities, there is newer technology, and I believe the gun club has upgraded their systems for that newer technology, that it is outside the realm of a shooting gallery. Shooting range facility, if you read all the documentation that Mr. LeBeau provided, and I'm certain that the gun club has followed through on with their improvements to bring them up to a safer technology, that it's a different situation than shooting galleries. The law states shooting galleries, and I don't consider a shooting gallery the same thing as a shooting range facility. They're two different things. I don't think it's necessary to license a shooting range facility because the licensing requirements at the state level are for shooting galleries. And I'm not going to argue with that the council has authority to do licensing, but I believe in this case, licensing would be required under the Firearms Act, under the state, to give us that authority. I don't think that they have for shooting ranges. And if they did, I would think, I'll beat that dead horse, I think it would come under the police chief and not the town council. Certainly the town council as a whole does not have expertise in gun club management or shooting range expertise. So I don't think that it is within our purview to do this licensing. And I think, as Ms. Nevigal mentioned, that it was a overreach, let me get these, an overboard interpretation of the state law. And I've been beating this dead horse for a long time, and I think as proof of that, the 30-odd gun clubs that have existed in Rhode Island since before the 30s and even after the 30s would have already been made to have licenses. Because right now in this ordinance, it says it's a crime to not be licensed. So it's contradictory. If they're required to have a license, then they should have had a license all along. And the rest of the state would be there already. Particularly Coventry, since they have a new commercial enterprise that's a shooting range facility. And certainly, as I noticed in the Middletown minutes of their meeting and documentation that it was also mentioned at their meeting, and they defeated the ordinance. So I don't really believe that this ordinance is necessary, as well as the licensing. On top of that, we have noise ordinances in town, and at the state level, pre-existing gun clubs basically have an exemption to what the noise ordinance was at the time of their establishment. And from my knowledge of these shooting range facilities, because I did go and visit the Mid-State gun shooting range facility, and you couldn't hear it outside. So I don't think there's any noise requirements, because the nature of the shooting range facility product, with its technology and its construction, would not allow, or it would be in line with current noise ordinances. And in fact, having a big building on Main Road would probably cut down on the noise for the residents behind it, because it would shield them from the noise from the traffic, because traffic has a lot more noise than the gun range would have. So I think, as far as noise goes, I think it's really a moot point and does not need regulation. We have current regulations in the ordinances for noise. I just had the lady that lived in the Haskins Avenue area asked the council if we would want to have one of these shooting range facilities in our backyard. And my answer is yes, because I think it's as many people who have come up to the podium and have spoken, they have said that it is more safer to have this shooting range facility with its newer technology than it is to have shooters going out in the woods, quarries or whatever, and doing shooting on their own private property. So I think it behooves us to embrace shooting range facilities and not discourage them, which I think we are doing by having this ordinance and licensing required. On top of that, this will set a definite precedence for the rest of the state, and who knows if our ordinance would be a model for that licensing, or whether they'd go even further so that gun ranges, gun clubs would be put out of business in their locale. It's a slippery slope, and it certainly will be picked up by every other town who have anti-gunner people who want to stop any type of gun activity. As far as safety goes, whether it's the gun club or a shooting range on Main Road, it's common safety practice to have your gun, and it's required by state law to have a trigger lock. So from that perspective, the gun will be in cases, trigger locks will be employed. So I don't see where there is a safety issue for people coming and going from any facility, whether it's a gun club or a shooting range facility on Main Road. There's safety that has to be taken into consideration, and I think gun owners know that and follow those best practices. They're not going to carry a rifle from their car and just bring it into the gun shop. I don't see that happening today. It's secure in a carry case. And I know I have many in my cellar. So I don't believe that that is an issue as well. I think it's more a matter of fear and an education issue that people are fearful. They think guns equal crime, and that by saying that it's a crime to have a license is basically saying that law-abiding citizens who have spent 81 years to and fro at the gun club have been committing a crime, and they're the criminals, and they're not. I think the tide has to turn, that it's not the law-abiding citizens who follow all the regulations and follow all the rules are made to feel like criminals rather than the criminals. I was talking to a gentleman not long ago that said it's not even a matter of education, it's a matter of if a crime is committed and a gun is used in the process, give them 20 years mandatory sentence in jail without a possibility of parole. And that would stop gun violence in this state. And I had to think about that. I had to think about that long and hard. And I said, you know, I never thought of that, but if that were put in place, maybe crimes with the use of guns would turn around and decline. But I certainly know that from studies, even governmental studies, proves that gun ownership helps to decrease the crime rate, not increase it.
I have one final comment, and then I'm going to shut up for the rest of the night. I just want to say that for all the differing opinions of this issue, of this ordinance and this licensing issue, I think this council has tried very hard to keep away from the sort of the typical debate about firearms. And I certainly have tried very hard to do that. And I differ in my opinions about this ordinance and whether it's necessary and whether there's a state law that requires it and whether there's a state law that makes it illegal not to have a license for these things. I differ in opinions with some folks. Certainly I will admit that. And I really hope I've been respectful of people who have had differing viewpoints than mine. But ultimately, I'm trying as best I can to consider all of the opportunities and the options and the process of a resolution of a topic. And I'm trying to listen to everyone. And I don't think there's any reason that we should imply that anyone who disagrees with us is somehow less than, or somehow uneducated, or somehow anti-gun, fearful, and stupid. I don't think that that's really appropriate. And so I really am... I don't think it matters much what I think about guns. It doesn't matter what I think about anything but what's in front of me, and which is whether or not I believe that this is required under Rhode Island state law, and whether or not it's appropriate to make a methodology that suits both our concerns and the folks who are going to be applying for these licenses. And I hope I've tried to do that, and I've tried to be respectful throughout the whole process, but I think objectively you can look at this process, and I think it would be hard to say that I were anti-gun and trying to prevent anybody from having guns or operating indoor shooting ranges. I just think that there ought to be some amount of oversight, and a license is the bare minimum, I think, and that's perfectly fine. So I close my comments.
Mr. President, I just had a couple of comments, and I guess to some extent I'm following up on what Brett is saying. What I did over the weekend in trying to review these statutes and review the opinion letters by Mr. Regan on behalf of the Rod and Gun Club is to see whether or not there was any accommodation at all. I think that probably if left to my own devices, I would have taken a more extreme position and perhaps exempted the Rod and Gun Club as a pre-existing facility. But I think it's important to recognize, even though we had some differences of a viewpoint expressed here tonight, that we do have, I assume from counsel, what may be the legal position of the Rod and Gun Club. And I'm only talking about the Rod and Gun Club at this point. Mr. Regan specifically sets forth the full statute of Rhode Island General Law 1147-54, and it reads in part as follows. Every person who shall keep any pistol gallery, rifle gallery, or other building or other enclosure in any city or town of this state where firearms are used without a license from the duly constituted licensing authority of the city or town shall, upon conviction, be fined, etc. Mr. Reagan's interpretation of that section is set out in his correspondence of July 21st, 2014 to the town council. He addressed this to the town council. And it's set forth on page 2. And I'll just read this. You can digest it and form your own opinion as to whether we believe that we have worked out an appropriate accommodation with people with organizations that have a real interest in this issue here in Tiverton. It states, and I'll read this, it's very short. Title 11, which I've just read in part, of the Rhode Island General Laws uses the terms shooting galleries and shooting ranges. However, it does not use them interchangeably. Shooting galleries are generally recognized as indoor facilities, while shooting ranges are generally recognized as outdoor facilities. The intent to permit the licensing of indoor shooting facilities is clear in the language of Rhode Island General Law 1147-54, which I just quoted from. And Mr. Reagan then goes on to state further, quote, after setting forth the statute in full, under well-recognized rules of statutory construction, the clear intent of the enabling legislation is to permit cities and towns to license indoor shooting facilities. And it concludes on that point, and I'm quoting again, if the council chooses to adopt a shooting gallery ordinance, it should be limited to indoor shooting galleries in accordance with the terms of the state enabling legislation, unquote. And I think, quite honestly, that's exactly what we've done. Mr. President?
Oh, sorry.
Mr. President, just really brief, I don't want to belabor it, I think I just want to touch upon a couple of points that have not necessarily been touched on, and also kind of give my perspective on things. Based on everything that I've been presented, based on everything that we have discussed.
Mr. Gerlach, I'm sorry, we can't hear you.
Oh, I'm sorry. I just want to touch upon a couple points that have not been responded to, and I'll just give a little bit of context for my read on all of this. Based on everything that has been presented to me, based on all of the discussions that I've had, based on pretty much 4 to 6 weeks of researching all of this, I do believe the town of Tiverton is within its legal right to proceed with this ordinance, and I think it is a prudent thing to do. My concern is for Tiverton, and I understand that there has been a historical precedent set across the state and probably even wider geographically, but my concern is with Tiverton. I think a couple things here. As a whole, if you look at this revised ordinance, I don't think we're asking for much when it comes to licensing. I think if we were really out to stifle recreation or business or what have you, we could have put a lot of obstacles in this. But if you go through this paragraph by paragraph, I mean, it's benign. I mean, it's not a heavy lift here. And as such, I have to imagine that what we are asking for is a bare minimum, and that any existing organization or future business, if they're smart, and I know in the case of the Rod and Gun Club that they are smart, they're doing more than, I'm sorry? I'm talking now. I don't think that the ordinance as written in the licensing process that we are requiring are going to have any negative impact on operations, on programming. It's certainly not going to have an impact on the local or state economy. I mean, I am not an expert in this area. I'm also not an expert in private detective licenses or running a small business or selling liquor or selling cigarettes or anything like that. But we still have a licensing process. And I think if we are to have an even keel and a standard approach for any sort of business in town that wants to do this, we should have a licensing process that puts them on even keel with any other business in town. So as written, I feel that this is a very light lift. And I don't think that we're asking for much. And I think it's the right thing to do.
I just have a couple of quick, I know it's late. Just quickly, just my thought process in this whole issue. Joan has already touched base on probably some of the things I was going to talk about anyway. But my first thought was, how do we get here to tonight? So basically it started with Mr. LeBeau wanted to open up an indoor range. And then an ordinance was then drafted. And in that ordinance, a lot of the language in the ordinance, actually, a lot of it didn't pertain to indoor ranges. So then we had to have amendments to that ordinance. And that was just recently. I believe there was some conversations between the gun club's lawyer and our lawyer to go over some of these changes. And now we're back to indoor-only licensing for tonight. So I guess I have a quick question is, I think this probably already was answered, so forgive me if I don't know that right now, is we didn't consult any third-party or subject matter experts in drafting this ordinance. That's correct?
We relied on our town solicitor.
Right, so we didn't have the... Andy, did you consult any subject matter experts possibly? I'm not sure if you actually answered that earlier.
I didn't consult any paid experts, no. I did consult the people at the Tiverton Rod and Gun Club. I met with them to hear the issues. We did research it, other communities throughout the nation, we did a rather extensive search online looking for other ordinances throughout the nation, and then tried to pull what we thought would be the best from those different ordinances, as we often did. We generally do not hire consultants on ordinance drafting unless there's some particular technical expertise, such as the quarry groundwater issue.
Okay. And just the last couple of quick points. I hate to bring up an analogy which would seem adolescent, but Peter Parker, Spider-Man, had an uncle, Uncle Ben Parker. And he had a saying which stated, with great power comes great responsibility. And somewhat with the inclusion of the Tiverton Rod and Gun Club, which has shown great responsibility in the operation of their facility, they have shown that they can manage the great power that leaves in and out of that range every day. And Mr. LeBeau possibly also could show plans for similar facility and operation. Now, we also heard that there were no other ordinances in Rhode Island that could be found, no other record of license from municipality could be found. I'm not sure if that means that there hasn't been licenses granted by a police chief, possibly. I'm not sure if that search incorporated that scope. So with that said, I'm also for protecting Tiverton. Yes, we live in Tiverton, but we also can't ignore the consequences possibly of what this decision could possibly mean for also Tiverton, which means we could possibly be facing lawsuits from not just our own gun clubs or facilities, but all over the state. That's a possibility. And I would like to protect us from a very, very costly lawsuit, and I would assume that the NRA probably will also get involved in this. So I'm very interested in protecting our citizens, and I'm also interested in making sure that we don't have to pay for a very, very expensive lawsuit, which is, I'm not sure how we're going to do that. So with that said, it's very difficult to argue the point, should we or should we not license indoor facilities. It's difficult to argue that point. But with that said, with what we're doing tonight, this will be the first of its kind in the entire state of Rhode Island's history. So we really have to be very, very careful on what is done here tonight, and we might have to study this further.
Okay.
Thank you.
One more question.
Excuse me. I have the floor.
I'm going to say something.
This ordinance, to me, and by what the Tiverton Rod and Gun Club has said this evening, what Mr. LeBeau has described in the facility that he's going to put together, this ordinance should have no impact on them at all, other than getting a license. Because if they follow all their own set rules and regulations, this ordinance would not impact on them. This, to me, is protection for those who may not be as diligent as the Rod and Gun Club and Mr. LeBeau. We don't know what the future will bring, but I will tell you, and as far as a lawsuit from other cities and towns, that is a stretch, because the only way that we could be sued is if our law does not apply to them. So there is no way that we could be sued by another town for a law that only pertains to the town of Tiverton. But, again, my concern is only for the town of Tiverton. I don't care what happened in Coventry. I don't care what happened in Middletown. My concern is the town of Tiverton. And we have to be careful that we protect all our citizens and make an ordinance that is workable, that allows people to do business, and if they are doing it the way that they propose and should, this ordinance would have no impact other than a licensing fee. And so I say, for me, this is a good move for now, because this is uncharted territory in our town. And I don't want to be looking back 5 years from now, 10 years from now, should somebody else come in and bring in a substandard shooting range or gallery, and we have nothing to go back on to say, gee, Mr. LeBeau put together a nice product, but John Smith did not, and we have no protection. So for me, I firmly believe in this ordinance.
After listening to Bill, he's right. This is a compromise. I really do think so. And I do believe in licensing. And the more I'm thinking about it, and I've had conversations with the Rod and Gun Club, I think that this is a simple procedure. It's much better than it was before. And Bill and Brett just convinced me that and I believed it all along, we need a licensing procedure. So I hope that the Rod and Gun Club will be able to live with this. It's much better than what was first proposed.
Mr. Shabbat?
Just a few more comments.
I just want to remind you of the lateness of the hour, and we still have more business.
I know it's late, but I think it's an important issue. So I think it needs to be heard. Question, I think that you think that there's no impact, but it's just a licensing thing, and the licensing will cost money. So there is an impact. So for the gun club to proceed, they have to apply, they have to pay for advertising, they have to do whatever is required in this licensing procedure, and that will be costly. So to say it has no impact, I think it does. And as far as you mentioned substandard ranges, it would behoove anybody who builds a shooting range facility to have already thought about the legal ramifications to that business and would absolutely protect themselves by not building a substandard facility. I do have one question. As far as we've been talking about the Main Street, the Main Road facility, the gun club, does this ordinance apply to the police range that's behind the DPW building, which is an occupied dwelling? And does it meet the setback requirements?
We'd have to look into that. And if they require a license, they will have to get one. Anything else? Because otherwise I'm going to move the question.
As far as Section 8-81, abandonment and discontinuance, we have seen a lot of buildings in town who may be out of business. If they're out of business for a year, they revert back to, this is on the zoning side, they revert back to their previous zoning, or current zoning classification, if it's a non-conforming use. Basically, if abandonment and discontinuation is left in here, then any facility that is built in the town as a shooting range facility ends up having difficulties in being reestablished as a facility.
If it's already in a zoned area for that type of business, if it's already in a zoned area with that type of business, that doesn't change the zoning.
They can still put another.
If someone else bought it even after a year, they just have to apply for the license.
Right.
For Section 8-63, for fees, I'd like to reduce the application fee to $50. I make that as a motion.
May I
Second.
ask, Town Clerk, what our typical fee is for an application for a license? What's a typical fee for, say, a victualer's license? $50.
I don't care.
I don't care about that.
Okay, we have
I
a
will-
motion.
I will second the motion.
A second. Any discussion?
It's already a motion on the table, right? Well, that would be the amended motion. So, but that would be the amended motion.
Okay. You all need to talk into the mics, particularly on the table here, because I can't hear.
I'm asking the protocol for. I will do my best. Ed Roderick seconded the motion. Seconded
Yes.
the motion.
So
My question is, there was a motion and a second on the table. Councilwoman Shabbat just made another motion, and someone seconded it.
Brett, would you just read your motion again?
But that-
We'll vote on it.
My,
Oh, no, she's made an
wanna know-
amended motion.
hang on, let me get my question answered here.
To move the $50.
Andy, do you understand the salient details of my question?
Yes, I do.
Okay,
And there is a motion on the table to actually pass the ordinance as amended.
Correct.
That was made
about an hour and a half
about
ago.
an hour ago,
Yeah.
seconded by the chairman, by the president, and then the discussion has ensued since then. And there's now a new motion to amend. So a motion to amend the principal motion can be made at any
Okay.
time.
Excellent.
So,
So we have a motion to,
So,
we have a motion to amend Mr. Pelletier's motion to change the fee to $50. That has been seconded by Mr. Lambert.
I have
Any
one
discussion on
quick
that?
question. One quick question, Andy. Is the statute, what does the statute say regarding fees? Does it set a number, or is it our discretion?
I think
I-
the fine is 200.
I thought it did, I think it doesn't set the fee. I think the fee is at your discretion.
Okay.
Yeah.
And I have no problem with a $50 application fee.
Okay, so we have a motion and a second. Any further discussion on, but we are voting on
Only
the
on-
ordinance as amended.
No,
With the change.
We're just voting on this amendment,
Right,
not the overall motion.
the change to $50.
Correct.
So, if we have a roll call, starting with Mr. Gerlach?
No, we're voting for just the change of the fees. That's-
Correct.
Okay. Aye.
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 Aye, and I will move the previous question.
Okay. We have a motion and seconded to adopt the ordinance as amended.
Do we need a second to move the motion?
Second.
Only if there is
Thank you.
no debate.
I second it.
Only if there's no.
Okay, so we have a motion to adopt the ordinance as amended.
With a $50 fee instead of.
And
everything
all- And
else,
all
yeah.
the other previous amended items. We have a motion and second.
What's the fee?
Okay, I will call for a roll call vote, starting with Mr. Gerlach.
Nay. I'm going to vote nay, because I believe that the police chief would be a better body of licensing than this body for this type of issue.
I vote nay.
Aye.
Aye.
Yes.
Motion passes. Okay.
I move a-
Appointments and resignations.
Ed, can I move a recess?